We spent a lot of time on this deep dive dissecting constitutional law, specific articles, technical amendments, really complicated court cases. We are usually deep in the weeds.
We are.
But I think before you can really understand the rules of the road, you absolutely need to understand the destination. You need that founding philosophy.
Exactly. I mean, think of the Indian Constitution as this massive, intricate legal architecture. You've got thousands of articles, schedules, cross-references. It's a lot. The preamble isn't just the front door. It's the conceptual drawing board. It's what our sources actually refer to as the soul of the Constitution, the highest level summary of the national mission.
And that's what we are deep diving into today, the preamble. And for you, the listener, if you can understand this core philosophy, the explicit promises that were made to the nation, it really acts as the ultimate shortcut.
Yeah.
It cuts right through all that complexity, and it instantly gives you a grasp of India's entire founding identity. The principles the framers were so committed to securing.
And our mission today is to trace this philosophy all the way back to its inception, to the initial draft that was known as the Objectives Resolution. We'll analyze how the final preamble serves two really crucial functions.
Okay.
First, defining where the authority originates, which is we the people. And second, listing those national objectives, the ideals of sovereign, socialist, secular, democratic, republic, and then those moral commitments to justice, liberty, equality, and fraternity.
We're not just going to define these words.
No, absolutely not. We need to examine their legal and their social power and how the courts use them as this essential interpretive tool, to resolve constitutional ambiguity whenever it comes up.
Okay, let's unpack this. We have to start at the very beginning, before the Constitution even began to take its definitive shape. Because the preamble, it's not an afterthought, is it? It's a meticulously polished version of an earlier blueprint.
That's exactly right. The Objectives Resolution.
The Objectives Resolution.
Drafted by Pandit Nehru, and it was adopted by the Constituent Assembly on January 20th, 1947. Now, crucially, this happened before the Detailed Drafting Committee, the one led by Dr. B.R. Ambedkar, had even begun its rigorous work.
So this wasn't just a section of law.
No, not at all. It was the ideological mandate. It was the core against which every single subsequent article would be judged.
The gravity of this document really can't be overstated. I mean, Nehru wasn't just presenting a set of draft clauses. He was presenting a national oath.
He was.
He described it as a declaration, a firm resolve, a pledge, and for all of us, a dedication. It sets the entire emotional tone for everything that was to follow.
And the intent that was embedded in that resolution was, for the time, it was absolutely revolutionary. It laid out the fundamental foundation for the future state, starting right there with the declaration that India would be an independent sovereign republic.
Right. And in the context of 1947, still living under the shadow of British rule, this was just a clear, definitive statement.
An absolute statement, declaring the end of all outside political control, period.
So, beyond that break from history, the Objectives Resolution also defined the geography, the very structure of the Union. And that definition of federalism is particularly insightful, especially when you think about the power balance between the central government and the regions.
It established India as a union of states, and it incorporated all territories, British India, the Indian states, and any other parts that wished to join.
Okay.
But the key structural commitment, which really signals a deep desire to prevent over-centralization, was that the units, so the states, would be autonomous and they would retain residuary powers.
This concept of residuary powers, it's often confusing, isn't it? Especially when people look at India's strong central government today. So how did the framers' decision to assign these powers to the states in that initial resolution, how did that reflect their immediate concerns?
Well, it was a really powerful political statement and a safeguard. Retaining residuary powers for the states meant that they would control all powers that were not specifically enumerated and given to the Union to the central government.
I see.
So this was designed to reassure the princely states and other units that were joining the Federation that, look, you will maintain regional self-governance, you'll have flexibility.
So even though the final Constitution did adjust that power dynamic a bit, favoring the Union.
Right, it did. But that initial blueprint, it strongly signaled a commitment to decentralized authority, to ensuring states had that breathing room against what could be a potentially very powerful central entity.
And then there's the most important statement in the entire resolution, which became the opening of the preamble itself, about where authority truly resides.
Precisely. The resolution asserted that all power must be derived from the people.
Right there.
That declaration, it instantly and irrevocably shifted sovereignty away from the British Crown, away from the British Parliament, and deposited it squarely into the hands of the citizens of India. That is the foundational democratic mandate.
So the objectives resolution gave us this philosophical core, setting the goals of justice, equality, liberty, and, just as vitally, inclusion.
Yes, the core goals guaranteed justice, equality, and liberty for all the people. But, and this reflects the complexity of India, the resolution also specifically guaranteed inclusion. It did this by providing adequate safeguards for minorities, backward and tribal areas, and the depressed classes.
So the framers knew right away.
They recognized that without specific protections for the historically disadvantaged, any promise of general equality would just ring hollow.
So the preamble that we read today is essentially the poetic summary of that rigorous revolutionary document. It's the Constitution's calling card.
It is. It's considered a faithful reflection of those original ideals. So when we scrutinize the preamble, we can recognize its dual purpose. First, it proclaims the source of authority using that opening defining phrase, "We, the people of India."
There it is again.
It confirms that ultimate popular sovereignty.
And the second function is, well, listing the national objects and the goals.
Correct. It defines the character of the nation and the goals it seeks to achieve. To constitute India into a sovereign, socialist, secular, democratic republic.
And to secure
Justice, liberty, equality, fraternity to all its citizens. It is, the comprehensive promise of nationhood.
This brings us to a really crucial legal question, and it's one that often confuses people. We know the preamble isn't just decorative text, but our sources are very clear. It's not directly enforceable in court.
Right.
You can't just walk into a courtroom and claim your right to fraternity has been violated without referencing a specific article.
Yeah.
So what is its actual power?
Its power is profound, even if it is indirect. Its true legal utility is as the master key. It's an interpretive tool. If a specific constitutional article or a legislative act is ambiguous, or maybe if a conflict arises between two constitutional principles, the court will look to the preamble.
To see what the original intention was.
Exactly. To understand the original intention of the framers, it acts as the anchor, ensuring that all subsequent legal interpretations align with that fundamental, non-negotiable founding philosophy. In essence, it guides the entire judicial understanding of the spirit of the law.
And this reliance on the preamble as an interpretive guide, that must be what allowed the judiciary to later develop doctrines like the basic structure doctrine.
It is. It ensures that the essence of the preamble's promise can never be eroded, not even by amendment. It's the constant reference point for the national identity.
So it's the ultimate measure of constitutionality.
It is. If a proposed law undermines the core principles laid out in the preamble, if it compromises sovereignty or removes secularism or undermines democratic principles, the courts have a legal and a philosophical framework to intervene.
Even if the Constitution doesn't explicitly forbid that law in technical terms.
Exactly. The preamble provides the spirit, the fundamental structure that must be protected.
Okay, let's define some of the terms that define the state, starting with the two foundational pillars, sovereign and republic. These were the terms that officially shut the door on the entire colonial era.
Being sovereign meant declaring absolute independence. It meant asserting that India is a fully independent authority, both internally and externally, completely free from any dictates or control from outside powers. It is the declaration of total mastery over its own destiny.
And the shift to a republic was the formal final break from the British Crown.
Absolutely. Moving from being a British dominion to a republic meant replacing the hereditary monarch as the head of state with an elected president. That moment of formal transition, January 26, 1950, that marked the definitive end of the Crown's claim on India.
So today, the British Crown holds, what, zero constitutional authority?
Yeah, zero. None whatsoever within the nation.
This leads us directly to the point that always seems to raise eyebrows internationally. How can a completely independent sovereign republic, which has rejected the monarchy, still voluntarily remain a member of the Commonwealth? Which is, symbolically headed by the British monarch. It seems like a contradiction in terms.
It does seem like a paradox, and it's often misunderstood. India's decision to remain a member was not a political or a constitutional compromise. It was, in fact, a profound diplomatic restructuring. Our sources make it very clear that India's choice converted the British Commonwealth, which was a relic of imperialism, into a free association. It transformed it into the modern Commonwealth of Nations. India basically set the precedent for how former colonies could engage on an equal footing.
But how do we ensure this association doesn't even symbolically chip away
Yeah.
at India's complete sovereignty? What are the legal protections there?
The protection lies in the nature of the arrangement itself. It is entirely extra-legal,
Extra-legal.
meaning it is a voluntary agreement, it's a diplomatic gesture of free association, and it is not even mentioned in the Constitution. India can withdraw at any time it wants.
So there's no legal bond.
None. And crucially, the Commonwealth Charter states that India accepts the monarch only as a symbol of the free association. The British monarch has zero functions, zero power, and zero claim to allegiance from any Indian citizen.
And decisions made at Commonwealth conferences.
They're purely consultative. They are not binding on India's government. It is purely an international forum for cooperation completely detached from domestic law.
That distinction is crucial. Association without obligation, without submission. And this focus on international relations wasn't limited just to the Commonwealth. The founding vision committed India to a much broader global role.
Correct. The commitment to world peace and justice, which was, implicit in the objectives resolution, is formalized within the directive principles of state policy, specifically in the powerful mandates of Article 51.
And this elevates it. It moves the nation's international relations from just being foreign policy into a constitutional commitment.
It does. The article directs the state to proactively promote international peace and security, maintain just and honorable relations with other nations, foster a profound respect for international law and treaty obligations.
And it has a very specific instruction for disputes.
A very specific one.
Yeah.
To encourage the settlement of international disputes by arbitration rather than by conflict. So this embeds a commitment to global responsibility and peaceful resolution directly into the heart of the governance manual.
Moving back domestically, the preamble promises a democratic republic. The term democracy here is deceptively simple. It's not just about voting. It describes both the framework and the culture.
Exactly. The preamble signals a dedication to two very distinct concepts. You have political democracy, which is the visible structure, the form of government, dealing with elections and accountability.
Right.
But the deeper, more enduring promise is social democracy, which is the required spirit of the society. This demands that the nation be infused with the spirit of justice, liberty, equality, and fraternity, making the social conditions ripe for political freedom to actually mean something.
So focusing on that political structure first, India chose a specific model of democracy. It's not a direct democracy where people are voting under every single law.
No, it's a representative democracy. Power is exercised by representatives who are elected by the people to the parliament at the center and to the legislatures in the states.
And it's also parliamentary democracy.
Right. And it functions as a parliamentary democracy, which means the actual executive power, the prime minister and the council of ministers, is held directly accountable and responsible to these elected bodies. This ensures that the executive must always maintain the confidence of the people's representatives.
Okay, now we can delve into the core promises of the preamble. The first is justice, political, economic, and social. Let's start with the mechanism that delivers political justice to every single Indian citizen.
The most immediate and powerful mechanism for that is universal adult suffrage, which is enshrined in Article 326.
Universal adult suffrage.
Yes. When the Constitution was adopted in 1950, granting the vote to every adult citizen immediately, regardless of property, education, caste, or gender, was a massively radical step.
Especially compared to other democracies at the time.
Oh, absolutely. Contemporary Western democracies often still had property or education restrictions, so this was a huge leap.
The significance of that just cannot be overstated. It was a leap of faith for a new nation, guaranteeing the principle of one man, one vote from day one, giving every single person equal political value.
It was a declaration of fundamental dignity, and this political justice is structurally supported by foundational rights, most notably the guarantee of equality in public employment under Article 16.
Which ensures?
It ensures that access to state opportunities is non-discriminatory and open to all citizens, regardless of their background.
The goal here, as reflected in our sources, is ensuring that every citizen feels a real sense of belonging, making political equality a lived reality, not just some promise on a piece of paper.
The practice of including religious and social minorities in high offices, as ministers, Supreme Court judges, even president, demonstrates this commitment. This deliberate, practical inclusion is meant to make every single citizen feel that this country is his own.
It institutionalizes a sense of ownership.
A universal ownership and commitment to the state, yes.
But, as we've heard, the framers knew that a vote doesn't solve poverty. And this is the argument for expanding the scope of democracy beyond just politics, bringing in social and economic democracy.
Exactly. This defines the nation's commitment to being a welfare state, the overarching goal of the directive principles of state policy.
This is where the tension really arises. You can't sustain political equality when there's severe social and economic deprivation. Pandit Nehru articulated this so well.
He did. He warned that a vote by itself does not represent very much to a person who is starving or hungry.
And the philosopher Dr. Radhakrishnan drove that point home, stating that poor people cannot be proud of the Constitution or its law. If the Constitution doesn't meaningfully improve your material existence, then why should you defend it?
This urgent need to connect the vote to daily life is precisely why we have to address Ambedkar's Trinity, the foundational concept of social democracy. Ambedkar's warning is, I would argue, the single most important philosophical statement in the entire founding process. He stated, and I'm quoting here, "Political democracy cannot last unless there lies at the base of it social democracy."
So what exactly did he mean by social democracy that makes it so different from just political participation?
He defined it as a transformative way of life that recognized liberty, equality, and fraternity as a necessary union of Trinity. This wasn't just, a nice list of virtues. It was a structural necessity.
The union of Trinity. That phrase, it's just the dependency. If you separate them, they lose their power.
Exactly. And that was Ambedkar's core warning. You cannot divorce one from the other.
What happens if you do?
Well, if you champion liberty, say freedom of expression and movement, but you ignore entrenched social and economic inequality, that liberty only benefits the powerful.
And the other way around.
Conversely, he noted that equality without fraternity, without that spirit of brotherhood, can just lead to enforced conformity rather than genuine social cohesion. The three must function as a self-sustaining unit to make democracy real.
This moves us directly into the realm of economic justice, which is about tackling the distribution of wealth and resources, which is essential to sustain that trinity.
The goal of economic democracy, as it was envisioned, was not state control for its own sake. It was the systematic banishment of poverty.
Okay.
And this was to be achieved through two parallel routes: the multiplication of the national wealth, so growth, and its equitable distribution.
That's a crucial distinction.
It is.
Yeah.
The framers were very clear that this justice was not to be achieved through the forceful expropriation of all private property. That explicitly set India apart from, say, totalitarian command economies.
So the goal was a better distribution of a growing pie, not necessarily seizing existing private property just to achieve immediate equality. This really set the stage for the later adoption of the socialist goal.
Absolutely. So moving from that abstract philosophy to the enforceable rights, the ideals of liberty and equality that are enshrined in the preamble are then concretized in the fundamental rights in Part 3 of the Constitution, which can be enforced in a court of law.
Okay, let's trace how. Where do we find the assurance of liberty?
Liberty, meaning freedom of thought, expression, belief, faith, and worship, is primarily guaranteed through Article 19, which protects various civil liberties, and then Articles 25 through 28, which ensure freedom of conscience and religion.
It's important context for the listener, though, that the Constitution is clear. This liberty is not absolute.
Not at all. It is subject to necessary social restraint to maintain public order, morality, and health. It's another example of balancing individual rights with the needs of the collective society.
And the commitment to equality is detailed across multiple articles, all designed to dismantle the historical social hierarchies that plagued the subcontinent for centuries.
Absolutely. The rights are designed to eliminate institutional discrimination. So Article 14 provides equality before the law. Article 15 bans discrimination based on religion, race, caste, sex, or place of birth.
Article 16 we mentioned.
Right. Article 16 guarantees equality of opportunity in public employment. And then there's this singularly powerful Article 17, which legally abolishes the practice of untouchability.
And even economically.
Even economically, the directive principle in Article 39D aims for equal pay for equal work, regardless of gender.
These aspirations, equitable distribution, control over the means of production, social welfare, they naturally led India down a particular economic path, one that was explicitly formalized later as socialism.
The initial goals of the welfare state were always aligned with a socialistic pattern of society. The 1955 Congress resolution formalized this domestic goal, defining that pattern as one where the principal means of production are under social ownership or control.
And this predated the official inclusion of the word in the preamble by decades.
By decades, yes.
Which brings us to a moment of significant constitutional revision. The word socialist was officially added to the preamble. This was via the controversial 42nd Amendment in 1976. Why the delay, and what did that inclusion really signify if the goal was already present?
The delay, it stemmed from debates among the original framers about whether to restrict the nation to a single economic doctrine. But by 1976, the socialist commitments were so pervasive through policy and the DPSP that the amendment was seen as simply making the commitment explicit.
But this definition of socialism, it has to be understood as unique to India.
Oh, absolutely. It's emphatically our own brand, as Prime Minister Indira Gandhi put it.
So how does India's brand of socialism differ from the models that were prevalent in the mid-20th century, like the Soviet model?
Well, it's a deliberate rejection of pure state control. Our sources stress that just nationalization is not our type of socialism. It avoided that kind of dogmatic state ownership.
And the Supreme Court's interpretation?
The Supreme Court has interpreted this concept as meaning the elimination of inequality of income and status, and the provision of a decent standard of life. Operationally, it translates into a mixed economy.
Allowing both private and public sectors.
Exactly. It allows both private enterprise and state control, where the state uses regulation and policy to restrain private accumulation and focus on public welfare rather than abolishing private property entirely. It is pragmatic socialism, focused on welfare, not on dogma.
So if that's the definition of the state, let's move to the social glue, fraternity. This is the commitment to brotherhood that is meant to sustain diversity.
Fraternity is absolutely essential for the survival of a diverse nation. It's defined as the spirit of brotherhood among all citizens, and it's necessary for securing the unity and integrity of the nation.
And the word integrity was also added by the 42nd Amendment.
It was, to underscore the indivisible nature of the Union. And to achieve this, the sources mandate abolishing untouchability and eradicating all communal or sectional or even local or provincial antisocial feelings that could tear the national fabric apart.
And the indispensable condition for that fraternity, in a land of such religious pluralism, has to be secularism.
The commitment to a secular state is the key to ensuring fraternity across faiths. This means the state is religiously neutral. It protects all religions equally and critically, has no state religion or established church.
So the state supports religious freedom for everyone.
For all faiths, including the freedom to practice, profess, and propagate one's religion.
And just like socialist, the word secular was formally added to the preamble by the 42nd Amendment in 1976. If the state was already neutral in practice, why was this addition necessary?
The judicial consensus on this is that the amendment only made explicit what was already implicit. The original Constitution already contained comprehensive guarantees for religious freedom in Articles 25 through 28.
So why add the word?
By making it explicit in the preamble, the government was cementing the principle against any future political challenges. But more importantly, judicial interpretation has strongly asserted that secularism is not merely a policy choice. It is part of the basic structure of the Constitution.
Meaning Parliament can't amend it away.
Exactly, even if it wished to. It is fundamental to the very identity of the nation.
That's a critical point. The preamble dictates what cannot be destroyed. The preamble speaks of securing the dignity of the individual, and this dignity imperative is where the ideals of justice and fraternity really converge. I mean, you can't have brotherhood if you don't respect the inherent worth of every individual.
And the maintenance of dignity is backed by the entire constitutional framework. It's secured by the combination of the fundamental rights in Part 3, which set the legally enforceable baseline, and the aspirational directive principles in Part 4, which push the state to create conditions where citizens are free from wants and misery. These principles mandate state goals like ensuring adequate means of livelihood, just and humane conditions of work, and a decent standard of life.
What's fascinating here is how the judiciary has taken this concept of dignity, which can seem largely aspirational, and made it enforceable.
The Supreme Court has done exactly that. The ultimate judicial holding is that the right to dignity is a fundamental right itself, flowing directly from the expansive interpretation of the right to life in Article 21.
So it's not just a goal.
No. That elevation transforms dignity from a mere goal into a protected, actionable legal claim, forcing the state and even private entities to respect it.
Let's detail how these preamble ideals have translated into tangible legal action, specifically focusing on gender justice.
The framers understood that progress required the advancement of all citizens. Our sources cite Swami Vivekananda's observation that a nation will not march forward if the women are left behind.
And the Constitution has multiple layers of protection.
It does. Directive principles like Article 39 ensure equal livelihood and equal pay for equal work.
But the commitment goes beyond what the state must do and extends to what the citizen must do.
Precisely. The inclusion of Article 51AE, which is a fundamental duty, is highly significant here. It makes it a constitutional obligation for every citizen to renounce practices derogatory to the dignity of women.
So it puts the burden on the whole society.
Yes, on the collective society, not just the state, to change cultural norms and eliminate discrimination.
And we've seen the legal system actively use this dignity imperative to enforce major changes, even when specific legislation was initially lacking. The Vishaka case stands out as a landmark achievement.
The case of Vishaka v. State of Rajasthan from 1997 is a pivotal example of the preamble's power. At the time, there was no specific national legislation on sexual harassment at the workplace, so the Supreme Court stepped in. They utilized the preamble's commitment to dignity, to equality, and the spirit of international conventions, specifically the UN Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, to create a set of legally binding guidelines.
Finding guidelines that govern workplace behavior nationwide.
Nationwide, yes.
That's amazing. The court basically used international law and the preamble's philosophy to essentially legislate on workplace safety, establishing that dignity included the right to a safe working environment.
It was a massive expansion of the right to life with dignity. The guidelines covered prevention, prohibition, and redressal, and they held employers directly responsible for preventing sexual harassment, thereby translating the preamble's abstract ideals into specific, enforceable HR policy.
This expansive, progressive interpretation of dignity, it continues to evolve, doesn't it? It encompasses even newer groups and identities, like the recognition of transgender rights.
This is a perfect example of the Constitution adapting to its own core spirit. In the 2014 ruling of Nassau v. Union of India, the Supreme Court declared hydrotransgender persons as the third gender.
And this wasn't an act of political charity.
No, it was a constitutional mandate rooted in the right to equality from Article 14 and the right to life with dignity from Article 21.
So what was the court's core reasoning for linking gender recognition to dignity?
The court reasoned that to compel an individual to identify as a gender they do not recognize for themselves is a profound violation of their autonomy and their personal dignity. They recognize that identity is fundamental to existence.
And then they issued these critical judicial directions.
They did, providing a blueprint for state inclusion.
And what were those practical directions that flowed directly from the preamble's ideals?
Well, the court directed mandatory recognition of the right to self-identify gender male, female, or third gender. Crucially, they directed the government to treat transgender persons as socially and educationally backward classes for the purpose of extending reservations in education and public jobs.
And practical steps as well.
Yes. They also mandated practical steps like providing separate public toilets and dedicated medical care, alongside taking active measures to end social stigma and discrimination. This directly applied the preamble's commitment to justice and dignity to a population that has been historically marginalized.
This entire discussion just shows the preamble's ideals as this constant engine for social reform. But let's close the loop on the balance of the constitutional system.
Right.
The flip side of rights are duties.
Rights and duties are two sides of the same coin. The fundamental duties in Article 51A, also added by the 42nd Amendment, establish the corresponding obligations that citizens must observe to maintain the ecosystem of rights they enjoy.
So for every freedom guaranteed, there's a responsibility.
There is. A responsibility like upholding the unity of the nation, promoting common brotherhood, fostering the spirit of secularism, and cherishing and following the noble ideals which inspired our national struggle for freedom. These duties are the citizens' contribution to sustaining the ideals laid out in the preamble.
So if we synthesize everything we've covered, the preamble is so much more than a statement of goals.
It is. It's the ideological nexus that ties the political framework sovereign democratic republic directly to the social imperatives of justice, liberty, equality, and fraternity. It's a definition of not just what the government is, but who the people are intended to be.
The political theorist Professor Ernest Barker, he was so deeply impressed by this comprehensive scope that he actually reproduced the preamble in its entirety in his own scholarly work on political theory.
He did.
And he argued that true democracy requires 4 conditions: a passion for liberty, respect for personality or dignity, a sufficient material existence, and common fellowship, which is fraternity.
And every single one of those elements is deliberately and explicitly covered by the Indian Preamble. It is, I think, a masterpiece of political philosophy, attempting to establish what Mahatma Gandhi famously called the India of my dreams.
That vision was an India where the poorest shall feel that it is their country, with an effective voice in its making. A nation where all communities shall live in perfect harmony without the scourge of untouchability, and where women will enjoy the same rights as men. It is a holistic, moral, and political foundation.
That sustained resonance and the respect it garnered from global theorists like Barker, it really speaks volumes about its success as a mission statement.
So for you, the listener, we'll leave you with this provocative thought. Since the preamble is the ultimate interpretive tool, reflecting the original fundamental intent of the founders, how does understanding the detailed context of the objectives resolution and the framers' deep fears about social and economic inequality undermining political freedom change how you view current political or judicial debates about the basic structure of the nation? And given the legal requirement of the fundamental duties, what specific, measurable responsibility do you feel you have in upholding that fundamental promise of fraternity and dignity in your daily life?